Criminal trespassing charges in Cherokee County should be taken seriously, even if the case seems minor at first. A trespassing conviction can lead to fines, court costs, possible jail time, probation, a criminal record, and restrictions on returning to certain property. In some cases, a trespass allegation may also be connected to other charges such as vandalism, theft, burglary, protective order violations, domestic disputes, hunting violations, or property damage. Understand the exact charge. Oklahoma has more than one trespass-related statute. A basic trespass case may involve entering another person's yard, pasture, field, garden, business property, or other private property without permission. Other cases may involve posted property, business premises, critical infrastructure, lodging property, or trespass connected to damage or theft. The exact statute matters because punishment, defenses, and required proof may change depending on the charge. A person accused of walking across rural property is in a different position than someone accused of entering a business after being banned, damaging property, or entering a restricted facility. Do not ignore the court date. If you receive a ticket, citation, summons, or notice to appear, do not ignore it. Missing court can create additional problems, including a bench warrant, bond issues, or a worse plea offer. Even a lower-level trespass charge should be handled properly. Write down the court date, time, courtroom, and case number. If you hire an attorney, provide the citation or court paperwork immediately to avoid missing deadlines. Do not contact the alleged victim without advice. Many people want to clear things up by contacting the property owner or complaining witness. That can be risky. If the case involves a business, neighbor dispute, family conflict, domestic issue, or protective order, contact may make the situation worse. If the court has ordered no contact, obey that order completely. Do not call, text, email, message through social media, or send another person to communicate for you. Violating a no-contact order can create new criminal exposure. Determine whether you had permission. Permission is one of the most important issues in a trespass case. Permission may be express or implied. A person may have been invited onto the property, allowed there in the past, permitted by a tenant or occupant, or allowed to enter for a limited purpose. For example, a customer entering a business during open hours usually has implied permission to be there. A person visiting a friend may have permission from the occupant. A worker, contractor, delivery driver, surveyor, utility worker, or tenant may have a lawful reason to be present depending on the facts. The defense should examine who gave permission, what the permission covered, whether it was revoked, and whether the accused knew permission had been withdrawn. Was there notice to stay off the property? Some trespass cases depend on whether the accused was told not to enter or knew they did not have permission. Notice may come from a property owner, lawful occupant, police officer, written letter, posted sign, prior warning, business ban notice, fence, locked gate, or other circumstances. If there was no clear notice and the accused reasonably believed they could enter, that may support the defense. This is especially important in rural property disputes, boundary disputes, hunting access issues, shared driveways, easements, landlord-tenant disputes, and family property conflicts. Property boundary disputes matter. Cherokee County includes rural land, farms, pastures, wooded areas, private roads, lake property, and family-owned property. Trespass allegations sometimes arise because property boundaries are unclear or disputed. If the case involves a boundary line, easement, driveway, fence, hunting area, pasture, or access road, the defense may need deeds, surveys, maps, photographs, lease documents, text messages, permission records, or witness testimony. A person should not be convicted of trespassing if they reasonably believed they had a right to be where they were. Do not make statements without legal advice. Statements to police, property owners, store managers, security officers, neighbors, or witnesses may be used in court. Even an innocent explanation may be misunderstood or taken out of context. You have the right to remain silent. You do not have to argue the case at the scene. If law enforcement is involved, be respectful, provide identification if required, and avoid making detailed statements until you have spoken with an attorney. Preserve evidence quickly. Trespass cases often turn on small details. Save text messages, emails, call logs, photographs, maps, GPS records, receipts, work orders, lease documents, hunting permissions, business communications, or proof that you had a legitimate reason to be on the property. If the case involves a business, surveillance video may be deleted quickly. If it involves rural property, photographs of gates, signs, fences, roads, and property markings may be important. Evidence should be gathered early before memories fade or records disappear. Watch for related charges. A trespass charge can become more serious if the state alleges damage, theft, threats, stalking, burglary, domestic violence, protective order violation, or refusal to leave. Oklahoma law provides increased punishment when a person enters certain property and commits or attempts to commit waste, theft, or damage. This matters because the case may not be only about entry. The state may try to prove the accused entered with a bad purpose or caused harm after entering. The defense should separate what can actually be proven from what is merely alleged. Possible defenses to trespassing. Possible defenses may include permission, lack of notice, mistake, unclear boundary lines, lawful authority, claim of right, necessity, consent from an occupant, insufficient evidence, mistaken identity, false accusation, lack of willful or malicious entry, or constitutional violations. The best defense depends on the facts. A business ban case is different from a rural fence line dispute. A family property dispute is different from a case involving a locked gate. A hunting access case is different from a domestic-related allegation. If you have been charged with trespassing in Cherokee County, speaking with a criminal defense lawyer as early as possible can make a difference in the outcome of your case.